All right, good evening, everyone, and thank you so much for joining us for our exclusive Ask to Live conversation. To our panelists and all the participants, we want to thank you for taking the time to address this very important issue during such a time of uncertainty. And we are going to get started in just a moment after a brief opening statement from our panelists. But first, a few of the ground rules.
Yeah, so all of the participants we want you to remain cordial, respectful at all times. And we're going to first address questions that were submitted via email before this Facebook Live started. And then answer questions from you, the participants. First, we want to let you meet our panelist. Joining us today is managing attorney and eviction right to counsel, Donna Carney with Lone Star Legal Aid. Hey, Donna.
Also, we have the Honorable Judge David M. Patronella with the Harris County Justice of the Peace, Precinct 1, Place 2.
Good evening.
All right, and then we also have Zoe Middleton. She's the South Texas Co-Director with Texas Housers. Thank you all for joining us this evening to answer some of these important questions from our viewers and people who just have questions about evictions and the process. We want to go to Donna right now. You have the floor and can kind of give us some of your opening statements on this issue.
So first of all, I'm really grateful that KPRC is hosting this event. I'm with Lone Star Legal Aid, and we have been representing tenants in all sorts of different housing and other civil legal matters for over 4 decades. Lone Star Legal Aid has been in this arena and are here for tenants who are eligible for legal services. We feel like because of the pandemic, this has become one of the most pressing needs that Texans, low-income Texans in particular, are facing. And the unit that I manage is a group of attorneys and paralegals. We're working in a collaborative effort with other legal service providers in the greater Houston area to provide eviction defense. And to the extent that we can answer questions here for the public, I'm grateful to you all, the hosts here this evening, and to the other panelists for having us as part of this hour.
Okay, thank you so much. Next, Judge Patronella, please, quick opening statements.
Amy and Keith, thank you for hosting this as well. We probably in this, during this pandemic, we've now seen approximately 50 million Americans who have become housing insecure. This has been a very rough time for landlords and tenants both. And we've had to deal with quite a bit of changes, both in terms of rulings from the Supreme Court, and orders from the Supreme Court, and from the CDC order. So there's a lot of things that are out there. There's some good information and some misinformation. So hopefully we can get some things clarified that may help both landlords and tenants go through this pretty rough period of time for all of us.
All right, thank you. And Zoe Middleton, tell us a little bit about what your role and how you deal with evictions and how you're involved in this discussion tonight.
Right, so I'm the Southeast Texas Co-Director of Texas Housers. We're a policy advocacy organization that believes in low and middle income Texans' right to a safe and healthy home in a neighborhood of their choice. And obviously evictions are a huge cause of houselessness and of displacement and have a bigger impact on low and middle income folks and upper income folks. And so we have really been focusing on this issue for quite a while. But especially during the COVID-19 pandemic, given the economic crisis that it's put us all in.
All right, thank you so much. We certainly just thank you all for taking your time to be with us this evening. Real quick, just want to remind all of you, the participants, you're going to remain muted throughout the conversation, but we do want to hear from you. So you will be allowed to submit your questions in the comment section. If you're comfortable in being in front of the camera, you can use the raise hand feature. And remember, and on a member on our team will unmute you, and then you'll be able to ask your question. So we're going to go ahead and start with questions that we received earlier. And the first one can go to all three of you. From David J. David J. asks, please explain the CDC eviction ban. A lot of people are confused by this.
Well, I think I would like to start by not even calling it a ban, but an order. And maybe Donna can talk about why that's appropriate. But I think using these wholesale words like ban and moratorium are a little dangerous. It applies to only some evictions, not all evictions.
So yeah, I think Zoe really pegged it. We've heard the CDC ban called a ban. We've heard it called a moratorium. It's really neither of those things. It is an order. It came out of Washington, out of our federal government. And one of the important aspects of the CDC order is that it has a statement that it proposes that tenants can read through. And if that statement is true and accurate for that tenant, then that tenant can sign that statement with a really important caveat. That statement, if you sign it, you are signing it under penalty of perjury, and perjury is a crime. So if you're going to read that statement, and we can all sit here and read it and talk about it for a full hour, but I want to tell you as an attorney, as a licensed attorney, that it's not my place here and now in a broad conversation to give any particular person specific legal advice. I think it's imperative that tenants reach out to an attorney to get legal advice, to understand what their particular circumstances are with respect to the CDC declarative statement. Now, if you read that statement that the CDC offers and you understand it and you believe that it is true for your circumstances, then the protections are tremendous. Those are huge protections. One, the CDC says turn it over to your landlord. And we advise people to turn it over to your landlord in a way that your landlord cannot dispute that your landlord received it. Record it. Either turn on a recording device like your cell phone and take a video as you're turning it over to your landlord, or fax it or send it by certified mail, memorialize it somehow. But then also, we were advising people, think about filing it with the court if you already have an eviction case pending. And now the Texas Supreme Court, just 1 week ago, kind of said the exact same thing. They said, if you have a case pending, file this with the court so that the JP court judges aren't guessing what to do. We advise people, if you feel like that statement is accurate for you, not only sign it and file it with the court, but please put your case number on that statement so that the clerks of court are not inundated with lots of declarative statements and they don't know which case file it belongs to. If you need help with any of that, or if you don't understand how it relates to you, please reach out to an attorney, and Lone Star Legal Aid is willing to help with that if you qualify for our legal services.
So those were my questions. If I'm facing eviction, where the heck do I find that statement that I'm supposed to sign and turn over? And then how the heck am I supposed to find an attorney?
So Lone Star Legal Aid does provide that information on our website. In fact, there's so many different places where you can find that information. I know the Texas Housers offers it as well. I know that the Texas Supreme Court has offered it now and is urging the justices of the peace to post it as well when defendants are served that information with citation on eviction cases. With regards to Lone Star Legal Aid's resources, any tenant can go to lonestarlegal.org. You will find a very prominent link on our homepage. It's a red button, you cannot miss it. And you will find the declarative statement translated into several different languages to help tenants facilitate in finding, downloading, and printing that statement. If you need other assistance with that, you'll also find other resources through lonestarlegal.org.
Okay, all
And I
right.
think what's important to note about that declarative statement, once it's given to the landlord, once it's provided to the court, first of all, these only are in non-payment of rent residential cases. So if the landlord has filed against you because you brought 30 dogs on the premises and there's a no pet policy, or if your lease is up and they're filing after your lease is over, if you've had a 12-month lease and it's now the 13th month, or any other thing besides non-payment of rent, if then this would not stop the eviction. But if it is and the majority of cases are non-payment of rent cases. So if you file only for non-payment of rent and you as a tenant qualify and you do the declaration, file it with the court, it acts as a stay through the remainder of the year. So you as a tenant probably want to seek sources if you can to get rental assistance, and there's some programs available. I know we'll talk about it later, but it acts as a stay to keep the court from hearing your case for the remainder of this year.
All right. Thank you, Judge. I was going to say, just to reiterate, Donna, you said file that CDC statement with the court, with the JP, and with your landlord, just to be, because it sounds like the Texas Supreme Court now is saying that we need to file it with the court as well. Is that true?
That's correct. The most recent emergency order that relates directly to evictions, and that's emergency order 25 for anybody who wants to keep up with the numbering of those emergency orders, specifically says that any tenant that files that declarative statement with the court effectively operates as an order on the JP courts. And I'm happy to hear, obviously, from Judge Petronella, if I'm misconstruing that the JP court judges now have guidance from the Supreme Court to stay those cases. Stay meaning pause those cases. The case is not going to necessarily be dismissed. Right. It might, but it's not what the Supreme Court is ordering. It's ordering that the case be paused until the end of this year. I think, we're talking to the public, and I want to recognize that for a lot of people, the concept of filing something with the court is something they've never done, something they never thought they would have to do, and something they are absolutely overwhelmed at the concept of doing. When they're behind on their rent, they have a family member who's sick with the virus, they're unemployed, they don't know how to file with the court. And so I want to offer, to the extent that people are interested in obtaining free legal advice and potential direct representation, if they qualify, there is a group of law firms that are working to protect tenants. And the eviction hotline that is being offered in Harris County and City of Houston is available at 713-982-7340. And if I could just have a brief moment, Amy, I want to tell the public that this is a collaborative effort on behalf of Lone Star Legal Aid. We are working with Houston Volunteer Lawyers and the 3 law schools. It's a tremendous effort that's been put together by the legal services organizations in town to provide defense, not only for every tenant who is a US citizen or here with some sort of immigrant status, but also to every undocumented tenant, as long as they meet our eligibility criteria. I don't want people to try to figure out whether they might be eligible or not. Please call the hotline. If you are eligible for legal services, we will get you an attorney as soon as we can and help you file what may seem so hard to do. That is what the lawyers are there for. And that number again is 713-982-7340. That is the eviction hotline.
All right, for everybody, just what a reminder, those numbers, all the resources we were going to be talking about, in case you're trying to write everything down, they will be on our website, click2houston.com, the same article that you used to register for this event.
Okay. Judge Petronella, I know that a lot of people going through this, receiving these eviction notices, or if an eviction has been filed, they may be hearing or receiving or searching out help. And they come across some, I guess, of these individuals or businesses that claim that they can help. Can you tell us about some scams that maybe you've heard about people that?
There are some scams going on right now involving tenants who are being sued for non-payment. And there's some very unscrupulous characters who are charging anywhere from what I've typically heard, $100, $200, up to $350. I had a tenant the other day who was on by Zoom who said she paid $350 to a non-lawyer, which of course is unauthorized practice of law, to try to delay her case, is what she was told. And the woman would qualify for assistance through Lone Star Legal Aid or any of the other 4 entities. We would much rather see people who are in these predicaments go through the the law schools, through Lone Star, through the volunteer lawyers, and get legitimate legal help that's free of charge right now. There are a lot more resources available, and there are also right now through the county and city, there's rental assistance programs that are available to help some tenants who are short of funds. So there are some mechanisms, and in fact, I think Lone Star and the other groups are working in some cases directing those tenants to find assistance through the programs. Like Baker Ripley and the other programs that exist. So there are a lot of things that can be done if you're a tenant. Just don't fall for the scams that are out there. Unfortunately, when we go through these periods of time, we find a lot of folks that prey on people who are going through rough times, and they take their money, and oftentimes they don't offer good service for what they're doing.
Right. Thank you for that.
So yeah, definitely go use the vendors that Donna mentioned. And make sure if you're talking with attorney, ask for their bar license. They'll all be happy to give you proof that they are indeed an attorney and not somebody who's just there to take their money.
Okay.
All right, Zoe, this next one will be for you, but a Judge and Donna, you both can obviously jump in as well. This one comes from Valencia C, and she asks, can my landlord put me out even though she knows my situation? I've been keeping her updated on trying to find resources to pay past due and current rent that occurred when I wasn't able to work due to COVID at my job, and my children's school has been closed since March, or had been closed since March. Can the landlord put her out in that situation?
So I'm not going to do the unauthorized practice of law, right? We have an attorney and a judge on the case. This person found that they're a good fit for the CDC moratorium if they, make under a certain amount a year. But I think it's really important to recognize that the CDC order doesn't forgive any of the debt that tenants have. So Valencia is doing the exact right thing by seeking out rental assistance. People are still, over the course of this order, going to be piling up debt and potentially even late fees. And so that's why this order is really meant to just stop the spread of COVID-19 and to keep people housed, which is why it came from the Center for Disease Control. So I think this person is doing the exact right thing, and I'm going to let someone that is a Texas licensed attorney discuss whether or not, and under the circumstances which they can have an eviction filed, Valencia might have an eviction filed against her for non-payment of rent. But she's doing exactly the right thing so far by communicating with her landlord and seeking out assistance.
I think it's real important staying in contact with the landlord, letting them know what your situation, what efforts you've made. And if you qualify for doing the CDC affidavit, you certainly want to do that declaration, but get it done through a group like Lone Star Legal Aid or one of the other 4 entities. Get it done right. And one of the things that I've noticed, we've had quite a few landlords who've been willing to work with tenants and say, listen, we will try to do our best. We know things are bad. And so we've found the majority of the tenants that I deal with, the majority of the landlords that I deal with on a day-to-day basis recognize these are unusual times. And so they very often will work out payment plans. What I found in a lot of cases too, Zoe, that we talked about earlier, is a lot of landlords have been willing in these plans to waive late fees because they know things have been rough. Mm-hmm. And they'll say, hey, listen, we know we may be getting things later, but if you'll get us a plan, or if you qualify for through Baker Ripley or any of the nonprofits, we'll take those funds and accept them and work out a payment plan to do the rest.
I think, Donna, maybe you can answer this when you chime in, but does Lone Star representation help a tenant figure out a payment plan with their landlord? That's something that y'all would do, but I also think it's important that whatever plan you come up with is realistic for you and your earnings. Some people are going back to work and then getting sent home because the work site is deemed unsafe or there's been exposure. So make sure that you have a realistic plan. I know a lot of people are spending a lot on food right now, and there's no disaster SNAP or that kind of thing. So make sure it's realistic given your current expenses and the kind of times we're living in right now, and make sure that it's documented, that all of your conversations with your landlord are, as Donna said, in writing or in email or like recorded. Because we have seen when, debt rises and increases, that some landlords will become a little bit more aggressive, and it's important to have documentation of all of your communication with them.
I want to add a little bit to that, Zoe, and I think that those are all really, really important points. When an applicant contacts Lone Star Legal Aid, first of all, I want to address an issue that we've been asked on a number of occasions, and that is the information that I share with you all over the phone, will that information be kept confidential? And I want to assure the public that when you call us, whether you call our main number or if you call the eviction hotline, the information you share with us is absolutely confidential. We are bound as attorneys to keep that information confidential. There's nothing that we would take down that could later be used against you. The coalition does work together to the extent that there are undocumented families or undocumented tenants that will be assisted with direct representation by one or more of the coalition members that are working in this collaborative effort. And our goal is to make sure that the information that is shared is the basic minimal information that's necessary to get a tenant to the right advocate or the right attorney that will be representing them. When a person calls Lone Star Legal Aid on our main number and they have an issue going on that hints that they may also need help with public benefits, or there may be some other problem going on in their life. We hear a lot of issues related to domestic violence or other concerns that are civil in nature. We do provide a holistic civil approach. We don't handle criminal cases, but to the extent that anybody contacts us with an eviction issue or some other issue, that there will be an attempt to try to resolve a whole host of civil legal problems. And so to that end, I do want to also provide the main number for Lone Star Legal Aid. That's not, we will also deal with evictions on the main number outside of the hotline that I've provided before, but the main number for Lone Star Legal Aid intake is 713-652-0077. And I urge people, if you call and if we happen to be inundated with phone calls at the moment, if you get a voice recording, please do leave a message. Please only leave one message. You will get a call back. We have quite a machine of intake staff that knows how to respond and respond quite timely.
Okay. So we realize that our raise hand feature is not working, but some people are submitting questions through chat, and that is working. So we want to ask some of those as well. We've heard this one that was from Andre B. And we've heard these questions from landlords as well, wanting to know, landlords are at risk of, they're like, hey, we still have, if we have a mortgage on our property, we're not going to be paying that. Andre says, what about, say that our rental homes are mortgage free, but the tenants refuse to pay, will there be a moratorium on property taxes? He wants to know, like, how are we going to pay property taxes if we're not making any money on this property?
Yeah, obviously that's an issue. None of us here, none of the three of us have the authority to abate those taxes. That's up to the state and the county to collect the property taxes. But obviously a lot of people have been impacted by it. And that is something that, if you're a landlord and you have a conventional mortgage, right now you don't have a lot of protections. If you have a federally backed mortgage, if it was a Fannie Mae or a Freddie Mac type of mortgage, you have some CARES Act protection yourself. But if it's a conventional, maybe not so much. But that's why it's also, if you're a landlord, to maybe continue communicating with your lender that I'm in the process of trying to get things together, but because of the pandemic, I'm having difficulty getting rental income, and therefore tough for me to make the mortgage payments. So certainly this is a time where it's more important than ever to keep those channels of communication going, because I think most people, not everybody, but most folks are reasonable. And so if you say, listen, I'm going to be a little short this month, but I can catch up in another couple months, I think most folks are willing to do that.
I want to maybe go back to one of the prior questions, Amy, if that would be okay, talking about the filing of the CDC declaration, the declarative statement. I want to be very respectful that we have one of our 16 justices of the peace here, and with no intention of putting Judge Petronella on the spot, but recognizing that every one of our justices of the peace is certainly entitled to develop the cases in his or her court as they deem fit. The Texas Supreme Court, in its 25th emergency order, also opens the door for landlords to contest the CDC declaration. And what I mean by that is I don't want tenants to go file that CDC declarative statement and assume and be done with the assumption that their case is paused until after December 31st. There is a chance that they will be receiving communications from the landlord and or from the court if there are challenges. Okay. I think we see a lot of instances historically, and not just in eviction cases, but in debt collection cases, where the court tries to communicate with the defendant and the defendant doesn't get the mail, doesn't go to their post office box, doesn't check their mailbox, and will ignore, intentionally or not, that there may be a hearing that is set on something kind of related to the eviction, like whether the declarative statement contest is going to be set. And I don't know specifically how Judge Petronella is handling that in his court, nor am I intending to put him on the spot, but I do recognize that every one of the 16 judges is entitled to deal with that differently. Sure. And defendants need to be aware that they might get other communications from the court. Filing that statement doesn't mean you can go hit the snooze button until January 1st.
I guess, Donna, what I would always emphasize, and it's not just in addition to the 16 justice courts here in Harris County, the adjacent counties, and then the 4 county civil courts that hear all these as well. So there are quite a few judges that may have different takes on how to interpret it. That was part of the order that sort of, that I wasn't necessarily expecting, that because I sort of assumed that if it was filed that we would pretty much accept it. The only issue that I've had come thus far has been one person who filed a declaration both with the landlord and with the court, and they had neglected to check one of the boxes. And it actually was one that I considered one of the less important ones. And I think it was inadvertent. And so I said, okay, what we will do is reset this and allow you to, I said, did you intend to not check that box? And they said no. And the landlord said, well, they have to check all 7 or else it's not valid. So my resolution of that was to reset it to allow it to be done because I think the tenant would qualify. Here's what I think the general take would be by judges in the area. If a landlord wanted to challenge a declaration, is first of all, the declaration is presumed true once it's filed. So I think the burden would probably be on the landlord in a contest to say, I have some evidence that contradicts this, such as, when they rented the property in February, their income was $400,000 a year. And here's evidence of that. They said they've lost 20% income. Even at that rate, their income would be over. So I think it would probably be a burden of proof on the landlord to be able to challenge it rather than the tenant. It'd be probably the opposite of what a pauper's affidavit would be, where if you're saying you're a pauper for purposes of appeal or you're proceeding in form of pauperous, that you then present evidence. I think in this case, we had a discussion today amongst the judges, and I think the assumption is that if it is challenged, the landlord should not just willy-nilly say, I'm going to challenge it. It should have some evidence that you could be able to say, I want to refute this because here's my evidence that shows that this line right here cannot be true. Well,
and one step beyond that, if we, for just a quick moment, put aside the Texas Supreme Court order and go back to the CDC order, the CDC order lodges significant penalties against a landlord who is adamant about pursuing an eviction.
$250,000 penalties. it's pretty heavy if you as a landlord have received it, unless you just blatantly believe none of it's true. I would be very reluctant. This is probably a good time to, from the landlord side, that before you file an eviction with the new CDC order and with the Supreme Court interpretation under the emergency order 25, it's a good time to maybe visit with an attorney who understands landlord tenant law post-COVID, so that you don't put yourself in a position of you have a tenant who owes $1,000 in rent, and you're putting yourself potentially $250,000 in penalties. So it's pretty severe. I think that surprised all of us. I think with that they would come up with something. I don't know of other areas in the law where something which might be perceived to be this onerous. It's very hard.
Yeah. Zoe, so KKner asks, I'm going to be about $100 short this month for rent. Can I be evicted for $100? She's saying I can pay most all of it, but I'm going to be $100 short.
I think this person should speak to their landlord as soon as they can. And they should also, if their landlord makes movements towards, moving towards eviction, they should reach out to that Lone Star Legal Aid number. You can be evicted for any kind of non-payment of rent in the state of Texas, unfortunately.
Mm-hmm.
Yeah, I agree with what Zoe said. The thing is, I don't know that a lot of judges you'd probably look at a landlord and say, you've got a tenant that's been there 5 years and they've been paying rent every month. They lost their job or their hours have been cut back and they only owe $100 and you're suing for $100 rental. Yeah, I think some judges would balk at doing that, even though Zoe's correct in saying that any amount for a residential lease that's valid as a basis for filing non-payment of rent eviction.
It's understandable that people have this fear of being evicted for a small amount of rent, because what we're seeing is there's such a small supply of affordable housing in our area that people that are landlords that rent the more affordable units are actually kind of incentivized right now as people are trying to cut their costs to evict people that are late on rent. And so people are concerned that, there's a long line of people that could replace me as a tenant that are looking for somewhere more affordable to live, and I'm going to lose the roof that's over my head. So it's really understandable that people are concerned about even small amounts of rent.
Okay.
And there are a lot of, in addition to Baker Ripley, there are still some nonprofits that will assist tenants that need help. I know everybody's been stretched because there's been such a need lately, but there's a list of nonprofits that we're still having tenants come in and say, Judge, I got a pledge from Catholic Charities, or I got a pledge from Metropolitan Ministries, or I got a pledge from one of the long list of nonprofits. So in a case like where you're $100 short and you're working, I would certainly contact some of those nonprofits because a lot of them are able to help.
All right, we have our first live video question. It's going to come from Eric. Eric, we will unmute your microphone. Give about 1 second or so, and then you'll be able to ask your question.
How we doing? Thank you for holding this. I really appreciate that. I'm a property manager, and so I'm getting a lot of great information from this too. I think I've pretty much got my finger on the pulse of this, but Your Honor, you did say something. I mean, I could bogart all your time with all my questions and statements, but I'll try not to. Your Honor, you did say something earlier that about somebody being out of lease. Even if they have the CDC thing, if they're coming to the end of their lease.
If you're on, say, a 12-month lease and you give the tenant notice that you're not going to renew the lease,
right?
The tenant can also give that notice. The tenant can give that notice if that's a basis, but not non-payment of rent. You can't say I'm suing you because of non-payment of rent. I'm suing because the lease is up. We're reasonable if this might be a time where if it looks like a party needs an extra couple months and y'all can work out terms where you might want to do it, but non-payment of rent is really all that residential non-payment of rent cases are what are affected by the CDC. So if it is some other basis, and that would include holding over, disrupting, we had one not too long ago where I had a tenant who would have been able to follow with the CDC, and she filed it, but she also threatened the landlord and several other tenants and had emails that clearly showed she was threatening them. So you can't, everybody's a little on the edge of their seats with COVID right now. A lot of folks are anxious, but now's not the time to go Rambo on your neighbors or your landlord. If you've got a legitimate non-payment of rent case, you don't want to muddle it up by giving somebody reasons to evict you on other grounds.
And I might add, that is something that the tenant advocates are maybe seeing a little bit of and expecting a lot of, is that landlords might try to find other angles where non-payment of rent has been halted.
Yeah.
And we really encourage tenants to be in touch with their landlords and document that relationship, especially if it is a good relationship. Keep that relationship documented by text or email or whatnot to show that if something's changed drastically 180 degrees and you're suddenly accused of having 30 dogs that don't exist, you'll be able to show that this is a bogus excuse for eviction.
Yeah.
Okay. So Tammy G wants to know, does the office manager of my apartment complex have the right to request any supporting documents or other paperwork after receiving that CDC declaration form? It says via United States Postal Service certified return receipt, but not giving any verbal intent to invoke prior to mailing. Very specific.
I want to jump I want to jump through the computer screen and tell tenants that they also have consumer rights, and you have a right to financial privacy under the Texas Finance Code. And depending on who's asking, you may also have rights under the Federal Fair Debt Collection Practices Act. The CDC does not make it the landlord's business to ask you to reapply for the apartment or for the rental unit. And no, they are not entitled to that information. There may be a mechanism for the landlord to get to that information, and I'm not here to give that sort of advice out on a public forum. However, if a landlord asks a tenant for additional invasive financial information, it is absolutely not a tenant's obligation to respond with any of that. In fact, a lot of the information that a tenant might be asked to provide might be the sort of information that we would argue is the sort of information the landlord would only be entitled to if they obtained a judgment. And so no, if you're being asked to disclose and divulge personal financial information, unless there's a court order requiring you to do that, please do not provide your personal financial information in response to a request from the landlord. I'm so glad that that question was asked, because I trust that a lot of tenants would benefit from that information.
Mm-hmm. Keith, what's the next one?
Yeah. Another video question, actually. And this one comes from Nina. Nina, give us a second to unmute you, and then you can ask your question.
Okay, so my question is, basically this is the last month that I have in my apartment. I have not been able to pay the complete amount of rent. I did speak with the person in the office, and I asked her if I could have an extension. She said she would see what she could do. I could not renew my lease until the rest was paid off. And I have issues in the apartment, which is partially why I haven't been able to pay the rent, because I'm having to fix stuff in the apartment that they are not fixing. So I've told her, like, I need this fixed. It's coming out of my pocket, which is making it hard for me to pay rent. And I just continue to get the runaround. So what I want to know is basically, like, can I still be evicted since I'm at the end of my lease and they're not allowing me to renew? I mean, what do I have to do?
Did they give you a notice that your lease was up and they were terminating the lease in accordance with the rental agreement? Do they tell you that?
I just got one today saying that I had to pay the rest today, or they were going to file an eviction.
Or are they filing for non-payment or for holding over? Which right now for non-payment?
Yes, for non-payment.
Well, two things. One is first of all, you might want to check and see if there's 6,000 properties right now that are participating through the Baker Ripley fund, and you might qualify for assistance with Baker Ripley to see if they will do it. And if the landlord, the thing about Baker Ripley is that if they pay your rent for, let's say, this month and the month of October, and your landlord agrees to accept those rents, they can't evict you for the remainder of your lease term or the remainder of the year for non-payment. You can't, for non-payment of rent. Now, don't set the apartment on fire or anything and give them another basis, but for purposes of the rental assistance that's available, if you qualify for that, and a lot of people do and have, then that acts as in a way, a stay for further eviction for non-payment of rent. So that's one thing I would do. Also, one thing that concerns me is you said you told the landlord this, you told them that orally. Oftentimes people do that first, but if you don't get a response orally, it's a good idea to do it in writing, by email, preferably not text messaging, but by email or by written correspondence that you keep a copy of. So that way that protects you, gives you some notice. So if there are problems with the property, you give them notice that, the air conditioner's not working. I asked you to fix it orally. You haven't been able to fix it. So I'm giving you notice in writing, and you have additional rights to have those repairs made, but you're in a much better position if you can show that demand was made in writing, either by email or by a written letter.
Okay. Keith, do we have any more live questions?
Not at this moment. So we can move on to another one that emailed in. Yeah.
We've got a lot of them that people have sent in by chat. One woman, KII, says that she was locked out, but she did not receive an eviction notice. She wants to know what her rights are. Her request to re-enter was denied after the lockout, but she didn't receive an eviction notice for more than a month. So it kind of makes it unclear if now she has received one, but when she was locked out, she hadn't received one. When landlords don't even do the right thing in the beginning by filing the proper paperwork, what can she do or what should she do?
Well, if she was wrongfully locked out, she can file for a writ of re-entry. And, lockouts are a self-help remedy that landlords can avail themselves of. But probably during a pandemic is not a really smart time to do a lockout. And I've told this both to commercial landlords and residential landlords, that unless you think the tenant has abandoned the property and is gone, this is not a good time to do a lockout period. So, and the rights of a tenant are, for a residential property, is the landlord must make the keys available on a 24-hour basis, 7 days a week. And they're failing to do that, the tenant can get damages for the landlord doing it, but they need to file a writ of re-entry if they've locked out. If they're now back on the property, I would also think that for the time the tenant is locked out, they don't owe any rent for the period of time that they were locked out from the property. I have had landlords who've locked somebody out, then later file an eviction, let them back in, but they were locked out for 2 or 3 weeks. You can't have your cake and eat it too. You can't get rent when you lock a tenant out of the property.
And I might just add that is one of the sorts of housing cases that are not maybe a straight eviction case, a lockout case, or situations where utilities have been shut off and a person's deprived, let's say, of their air conditioning or running water, where I do urge tenants to reach out and see if they qualify for free legal services, not through one of these scam companies, and contact Lone Star Legal Aid or even the eviction hotline, even if it's not an eviction, so that they can get routed to an appropriate legal service provider.
Okay.
All right, but well, I mean, we have, this has been such a great conversation. We have a little less than 10 minutes left, so we want to get as many in as possible. And we actually do have another live question. This one comes from Pedro. Pedro, we'll open your microphone and you'll be able to ask your question.
Hello?
Yeah, we hear you.
Awesome. Well, I moved to this house 6 years ago, had a lease for 1 year only. We never renewed our lease, and we've been in good terms with my landlord. This up until a month ago. He's the one that suggested and gave me the link for Baker Ripley. I got pre-approved, and today they haven't sent anything else. I'm still waiting on Baker Ripley. Today he informed me that I have until the end of October to vacate the premises. Is that legal?
Well, let's see. If you're, well, here's the thing. If you, first of all, the general rule in Texas is the statute of frauds would prohibit a lease for 6 years without it being reduced to writing. And if you had gone to Lone Star or another lawyer and said, hey, don't I need to have a written lease? They would say, yes, you need to have a written lease because you've been conveyed property now for 6 years. You know, we deal with this from time to time. Has he agreed to accept Baker Ripley? And has he accepted it before? Thank you, Will. Can you hear me?
I'm sorry, Your Honor. Can you hear me?
Yeah. You said you qualified for Baker Ripley?
Yes, sir, I did.
And they accepted it?
He said he was going to accept it, my landlord, but up until a week ago, not even a week, like 3-4 days ago, he changed everything and he started saying that, yeah, he's going to accept it, but that
and I don't want to, if you're in, and I don't know whether this is something that may be filed in my court, so I don't want to prejudge what may happen. But
nothing has been filed, Your Honor.
Okay. What I would suggest doing is getting with Lone Star or one of the other one of the 5 vendors, either, and see if you can get some advice as to what's been done. You might want to also check, when you got confirmation from Baker Ripley, did you forward that email to the landlord to let them know that you had qualified?
Yes, sir, I did. And the thing is that now he's saying that I owe him money from over a year ago.
Okay. And is this an apartment or a home, standalone home, or is it
a house?
A house. Okay. Because potentially if it's an apartment and you potentially accepted it from one property, the other apartment units would also be prohibited from being evicted, having evictions filed. So what I would do is see if you can qualify for some legal assistance. Bring a copy of your old lease to the attorneys to see when it was originally drawn, whether some of those leases that are oral say the lease renews on a automatic basis, and that's what yours may say. And what'll be important is, does it renew on a month-to-month basis or does it renew on an annual basis? If it's an annual basis, then he's got to give you the appropriate notice. If it's a month-to-month, he'd have to give at least the 30 days. So what I would do is look at your lease, bring that to an attorney, have them look over it. But if it is renewed, if it was a 1-year lease and y'all never entered it into a new one, if the renewal provisions called for it to be renewed on an annual basis, if nobody did anything, then it's good for 12 consecutive months. And it would continue to be done in that way. If it was done only on a month-to-month basis, then it would be a month-to-month, and potentially the October date would be something you would be concerned about. And I don't know if Donna wants to maybe chime in.
Okay, I was muted there. Judge, I love the answer that you gave, and we're going to stick with that because we're very cautious not to give specific legal advice on facts where we're not, I don't know whether this person will intend to call Lone Star Legal Aid. I would like to see the original lease and make sure that we get the correct facts before we give out any legal advice.
Sure.
Certainly, if their landlord is watching, I'm not sure that I want to give any legal advice on this conversation, on this forum. So we'll gladly take phone calls though to the eviction hotline.
Yeah, just I always tell
Sure.
folks, don't. The worst thing you can do is just do nothing right now. Being proactive at this time is really important, because if you can stay proactive, in a lot of cases, you can avoid having the case filed in the first place.
And Judge, that brings us to our next question. We're getting pretty close, about 5 minutes until the end of our time here. But I'm going to kind of do a mashup from a viewer named Vanessa and a viewer named Tiffany. So Vanessa said, and just what you said, take some action, communicate, do something. The CDC order requires tenants to present this declaration to say, hey, this applies to me. So Vanessa says, what if a tenant fails to provide that CDC form and they're failing to communicate with their landlord, absolutely not cooperating? She's saying, can we file eviction?
Yes, there's nothing that would preclude you if it's an affirmative act that the tenant has to make. And so if the tenant does provide the CDC, then you probably want to hold back. But if you get nothing else, then no response, then there's not the use of the word moratorium or stay, as Donna said earlier, is really a misnomer. I wish the CDC, I think, captioned it wrong, and it really is almost like an affirmative defense that a tenant would raise to an eviction suit.
All right.
We are seeing in the news nationwide that Houston and Harris County are leading in the number of evictions.
Yeah.
So while I suspect, I don't know this for a fact, I suspect that many landlords have suppressed their desire or their need to file eviction, or their understanding of whether they can file for eviction. We're seeing low eviction numbers compared to maybe a year ago.
Mm-hmm.
We are still leading the country. We were neck and neck with Phoenix, Arizona for a while, but now we are leading the country in the number of evictions. And that is a testament to the number of landlords that continue to file and have since this pandemic broke out. And so I think that is one of the reasons why Lone Star Legal Aid and the Eviction Defense Coalition have come together to offer tenants this right to counsel, to make sure that people do have representation if they're going to find themselves defendants in the eviction litigation system. We're here for that.
Okay.
All right. Well, we are about at the end of our wonderful conversation here. So much great information. We hope it's been helpful. But first, before we go, we'd like to have some final thoughts from our panelists. And Zoe Middleton, we will begin with you.
Okay, I was typing a response to hi in the chat. Hi, my understanding is that you only need to provide the court with the signed and appropriately all the boxes checked on the declaration. I think Donna kind of hit the nail on the head for closing statements as to what I was going to say. Unfortunately, our region is leading in evictions right now. Since late March, there have been over 10,000 evictions filed in Harris County, and since the CDC order was issued alone, there have been over 1,200 evictions filed. And I think as any property manager and any renter knows, these are families and households, and it's really important to keep everyone housed so that we can resume and reopen safely and try to get back to normal. And I think it's important that both tenants and landlords are highly communicative with one another and understanding, as Judge Patronella said, that this is quite a difficult time. And so I understand that there might be some pressure for landlords to want to evict for reasons other than non-payment of rent or the small lease violations. I would hope that all the judges that hear evictions across Harris County would look at those very critically, right? And make sure that there isn't any debt that's also associated with those tenants. But we've seen that different judges are applying and educating on the bench differently and advancing cases or asking questions about cases differently. So I would like to remind landlords and property managers especially that there's a strong tenant advocate community here in Houston, and that we are very much watching out for instances of intimidation and harassment and retaliation against tenants, because nothing is more important than the place you call home.
Okay, thank you very much. Donna, Carney, any closing thoughts?
I do have, one closing thought and kind of, my urge for tenants. If you're falling behind on your rent, if you've gotten a notice to vacate, even if you've been sued for eviction, and maybe even if you've been handed an eviction judgment, please don't start packing right away. You may have rights that you're not aware of. There are lawyers that are willing to help if you qualify for legal services. Please don't be hopeless. Please do reach out. If you qualify for free legal services, that is our goal and our mission, is to help as many tenants as we can who are eligible. We've provided the number. It'll be on the website for KPRC. And I really, really want to thank our hosts and the co-panelists here for joining us and for making this possible this evening. Thanks so much.
All right.
Thank you.
Yeah, indeed. Thank you. And finally, Judge Patronello.
I guess I would just add that if you're a tenant that finds yourself in a tough time, go and speak to people like Donna and Zoe and try to get some advice. Don't let the problems that are going on with COVID and financial problems get to you to the point that you don't seek your legal rights. And there are still a lot of resources out there for assistance. I got a text early this morning from one of our local officials that indicated it looks like there'll be some more money coming out, hopefully soon. So there's an opportunity right now to try to address this. And I encourage landlords to be reasonable and tenants to be reasonable during this time as much as you can, and communicate. Make sure that you do things in writing so that you have a paper trail. So when you come to court, you can present things so that the judge, he or she, will be able to make a fair determination. Hopefully, we may be getting toward the end of this, but for a lot of folks, there are going to be a lot of folks who come January are going to be in difficult financial situations. So as much as can be done now before we get to January is real important.
All right. Well, thank you all so much again. Thank you for all of our panelists for joining us this evening. Also, thank you to all the participants who joined tonight's discussion. We hope that this conversation was helpful, also informative. If you have any other questions that were not answered, or if you have more questions, feel free to submit those to our website at click2houston.com.
Yeah, you can also check click2houston.com/ to look for information you may still have questions about. And we thank everybody for joining us here and sharing your knowledge. We know this is an important issue, especially right now in Harris County, Houston.
Yes, and again, for that, you can look for information again at click2houston.com/ask2, and that's the number 2.
All right.
All right. Thank you.
Thank you.